Jill. Next one up is Jill Downs, last name Downs.
Thank you.
And Judge, before we go on the record, I just wanted to again ask Mr. Regier if what we have requested is acceptable.
Mr. Regier, is what they've requested acceptable?
Are they asking me? No.
Nope. I'm asking the prosecutor.
One moment, Your Honor.
Yes. Mr. Nicholson, I just saw your chat. I'll get with you shortly. Thank you.
Your Honor, the state is prepared to proceed at this time.
Very well. On the record in 2024, TR 941, State of Kansas versus Jill Marie Downs. Jared Regier for the state, Darren Patterson for the defendant, Jill Downs, who also appears in person. And Mr. Patterson, you have some agreement?
Yes, Your Honor. And I am going to use the name of the charge because I'm not sure what order they're in, but Judge, in this case, I would tell a court that state has agreed to amend driving while suspended to no valid driver's license 8235. My client would be entered plea of guilty to that amended charge as well as guilty to fail to wear a seatbelt. State's agreed to dismiss, no proof of insurance.
Okay, looks to me like we have Mr. Regier officially driving while suspended is count 1 and seatbelt is 2. Is that what you're showing?
Your Honor, the ticket in this matter appears to list fail to wear seatbelt as count 1, driving while suspended is count 2, and no proof of insurance is count 3.
All right, and you did not file any kind of information?
That is what my records appear to indicate, Your Honor.
Okay, then I need to figure out why these are entered differently. Okay, Jen, do you have any information as to why the citation has them listed differently than the summary?
Your Honor, given the charges, the clerk's office does not enter these citations.
So who would need to fix that summary? Would that be KHP or would that be the county attorney? KHP or enters those, don't they?
I do not have knowledge of which entity enters it. We could go off of an amended information if the county attorney would be willing.
Mr. Regier, I know that causes you a little extra effort, but I would ask you to do that just because for some reason when it was entered into the computer, they popped up differently than what the citation issued. I don't know if the computer did that or if KHP or how that happened, but if I could impose upon your office to maybe file amended information.
Your Honor, in this particular instance, if the case does proceed to plea and sentencing, the state would anticipate filing an amended information to accurately reflect the terms of the plea agreement. So the state would not object at this time to proceeding in that fashion.
Okay, thank you very much. All right, at this time, Miss Downs, how do you plead to what I'm now calling count 1, driving while suspended?
And Judge, that count has been amended to no valid driver's license.
I'm sorry, to count 1, driving while suspended, now amended to violation of KSA 8235, driving without a driver's license.
Guilty.
And how do you plead to count 2, failing to wear a seatbelt?
Guilty.
Is anyone making you enter these pleas today by any threats or promises other than your plea agreement?
No.
Do you understand that you're waiving your right to a trial? You will be found guilty and unable to appeal your conviction.
Yes.
And you agree that you were in Butler County when you were doing this driving on March 31st of 2024?
Yes.
And do you remember where you were stopped for these violations?
Yes.
And where was that?
On Ohio Street. I was going to my brother's house for Easter.
All right, that's what the citation says, Ohio and Lakewood. So I have jurisdiction and I find you knowingly and voluntarily enter this plea. Your license was suspended at the time, or no, you did not have a valid driver's license at the time?
Correct.
Okay, and you weren't wearing your seatbelt.
Correct.
Then I accept your pleas and find you guilty, dismissing count three, as I'm calling it now, no proof of insurance, and recommendations for sentencing.
Your Honor, if the court is finding that amended count 1 is no valid driver's license under KSA 8235 and count 2 is the seatbelt violation, although that does not appear to comport with the order of citations on the ticket, at this time the state is recommending pursuant to plea negotiations for count 2, the statutory fine, which I understand is $30. For amended count 1, the state would be recommending a $100 fine, court costs, the court to make an appropriate determination on the attorney's fees. In this matter, the state is recommending pursuant to plea negotiations, the maximum underlying sentence of 6 months for a Class B misdemeanor, subject to a year of reporting probation, all standard conditions, and a $60 probation fee.
Mr. Patterson?
Judge, we just asked court to adopt recommendations. I can tell a court that Miss Downs has worked to get herself a restricted driver's license and continues to work on it to get to be valid. So we'd ask court to adopt these recommendations.
All right, then Miss Downs, do you work?
I don't, because I'm on disability. I can't work.
Okay. I will waive your court-appointed attorney fees, but you will have to pay a $100 fine on driving while suspended and a $30 fine on not wearing your seatbelt. You will have to pay $60 supervision fee, and you will have to pay $108 in court costs.
Okay.
I will order you to serve 6 months in the county jail if you are not successful on a 1-year reporting probation. So you've told me you're disabled. I'm thinking county jail may not be the best place for you, but if you don't comply with your probation, that may be what happens.
I will
Now,
comply.
You will have a standard list of probation conditions. And you go down to probation as soon as this hearing is over and tell them you're there to sign up. And then they'll set up a time to go over those conditions with you. I'm going to order that you keep working towards getting your license legal, fully legal.
I
Not
am.
just restricted, but fully legal. That's a condition of your probation.
Okay.
You're going to have to pay this money owed, which looks like it comes to well, I'm showing 298 and I don't know that that's right. But you're going to need to sit down with your probation officer and decide a minimum monthly payment. I'm going to leave that to the probation officer to figure out with you since you're on your disability and you're probably having to come up with some money to get your license legal. I'm going to leave that up to them.
Okay.
But you make some kind of minimum monthly payment.
I will.
All right. Is there anything else I need to address, Mr. Regier?
No, Your Honor.
Mr. Patterson?
Nothing further.
All right, then you head on down to probation, Miss Downs, as you are excused from these proceedings.
Okay. Thank you. Thank you, Your Honor.
You're welcome.
Okay. I just need this. And where's probation?
Right down the hall.
Okay.
Okay, the next one I have up is Al.
That hearing had a little bit of everything. Judge Webster handled Jill Marie Downs' case with her steady mix of formality and practicality. Downs appeared in person with her attorney, Darren Patterson, and the parties had worked out a plea agreement. The driving while suspended charge was amended to no valid driver's license. She pled guilty to that, and to not wearing her seatbelt, and the no proof of insurance count was dismissed. There was even a brief detour over the paperwork. The counts were listed differently in the system than on the ticket, but the judge smoothed that up by directing the county attorney to file an amended information so the plea tracked correctly. Downs admitted she was stopped on Ohio Street, heading to her brother's house for Easter, and acknowledged she hadn't had a valid license or worn her seatbelt. The state recommended fines, court costs, supervision fees, and a year of reporting probation with a suspended 6-month jail sentence hanging over it. Patterson noted that Downs had already started the process of getting a restricted license. Judge Webster waived attorney fees after hearing Downs was on disability, but still imposed the fines, costs, and probation conditions, including continuing to work toward a fully valid license. The judge's tone was firm but understanding, recognizing Downs' limited means while leaving no doubt that probation compliance was mandatory. The overall atmosphere stayed orderly and respectful, with the court making sure both the law and real-life circumstances were addressed. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.